And what have you done about that, sir?
I submitted the notice to appeal.
Okay. And have you done anything to perfect that appeal with the Kansas Court of Appeals?
I'm waiting. I literally just spoke to the court record, and they send it in. And the next thing is we're just waiting for the plea.
All right. First of all, I'm not making Mr. If Mr. McClendon has not withdrawn, I'm having him do so now because we do not, to my knowledge, pay for appeals of illegal tags. You'll need to be responsible for that yourself. And it's not enough just to file the notice that you intend to do it. You need to actually do it. So are you going to be representing yourself or hiring an attorney on that, Mr. Estrada?
I would like to get an attorney.
Well, you're going to have to hire one because throughout the trial, you kept insisting that you, if I'm remembering correctly, you didn't want an attorney. Isn't this one where I made Mr. McClendon stay on as kind of a backup counsel?
That's correct, Your Honor. He was essentially became standby counsel, and the court granted Mr. Estrada basically special consideration on this matter, as this is not even an offense that's eligible for court appointment, as it does not carry a sentence that exceeds 6 months.
Oh, yeah, yeah.
And I thought the court, maybe I was going to double check the journal entry. I was thinking Mr. McClendon, maybe even on the last journal entry, had been allowed to withdraw, but there was delay in me getting the paper, those journal entries to the.
All right, buckle up, folks, because today we're diving into a legal roller coaster that features not one, not two, but 4 sovereign citizens, each one determined to turn a courtroom into their own personal stage. We're starting in Kansas with a man who believes his homemade cardboard license plate is as valid as any issued by the DMV. Then we'll meet a prisoner who thinks he can outmaneuver the system from behind bars. Jump to a self-proclaimed Prince of Morocco, who's got more titles than actual legal standing. And finally end with a defendant who somehow ties child support to maritime law.
Have you seen anything about a waiver on his appeal bond?
No.
Well, I would deny any appeal bond. Mr. Abel, the facts in this case were very straightforward. You'd made up or bought a made up alleged tag that wasn't even close to being a legal tag. We spent a lot of money trying it, and I say a lot of money because I made the defense attorney stand by, even though you didn't want an attorney. Now you say you want an attorney to appeal it. Well, I'm sure not going to appoint one to appeal it. And if you cannot even afford your $158 appeal bond, I'm wondering how you're going to afford your attorney if you can even find one to take this kind of case on appeal. I would venture to suspect that it's never been done before, but if you think you can get it done, you're welcome to. But I am proceeding that until that appeal is perfected, you still owe $158 fines and costs, and you need that to pay that appeal bond. So I'm going to review this in 30 days, and you better have it all figured out, or you better have.
And there it is, the first crack in Abel Estrada's defense. He's pushing forward with an appeal over a license plate that wasn't remotely legal, yet he can't even scrape together the $158 appeal bond. The irony? This is the same man who was adamant about rejecting court-appointed legal help during his trial, but now suddenly wants an attorney. Viewers, do you think he genuinely believes in his case? Or is this about avoiding the consequences? Drop your thoughts in the comments, because from here, the judge's patience starts wearing thin.
Got it. I've never seen the charges or the journal entry. I'm trying to get all the information in.
That's all great, Mr. Estrada. The journal entry is being filed. Your Honor, I don't know that at least the state's not particularly interested in his steps to appeal. That's for him to figure out on his own. I do have one item to correct on the record, Your Honor. I think probably it's proper to note that Mr. Estrada was wanting counsel However, both court-appointed counsels, Mr. Paul and Mr. McClendon, both believe that Mr. Strada was also wanting them to violate their oath as an attorney and make arguments
That is incorrect.
Don't interrupt, please.
And make
Mr.
make arguments in violation of both the U.S. and Kansas Constitution was the specific statement both attorneys made to this court.
Yes.
That was all. I just wanted to correct it because he was asking for an attorney, even though, quite honestly, the case doesn't qualify for court appointment.
Oh, thank you for correcting the record.
Court still did grant him that an attorney, but the attorney's Mr. McClendon became standby because he believed that the arguments were not
fine. But isn't this a misdemeanor?
I just asked for the basic fine. What I refer to as basic fine. It's not really a scheduled fine, but it was $50 because he.
This is classic SovCit logic. Refuse legal help when it's free, then demand it when the stakes rise. Judges have heard this song and dance 1,000 times, and they know the ending. The kicker? 2 separate attorneys had already bailed on Estrada, saying his legal strategy would force them to violate their oath to the Constitution. Imagine your argument being so far off the rails that even lawyers who represent hardened criminals want nothing to do with it. That's where Abel is right now.
All right, March 28th, 11 o'clock. We're going to review this and see if you've paid your case and moved on, or if you're going to keep fighting it and never mind. All right, but I understand, Mr. Estrada, what is it you're appealing? The fine and court costs, or are you appealing the verdict?
I'm appealing the verdict.
Okay. And you want to maintain your argument that cardboard tag was legal. The tag that you made was legal.
Yes.
Okay. All right. I just wanted to make sure I knew what we were doing here. All right. I'll see you back here March 28th at 11, unless you paid your $158 balance. Thank you, sir.
Yeah. I just wanted to know, where do I get the report, the journal entry from Mr. D?
It'll be with the court. Look at the court.
The clerk of the district court is the keeper of journal entries.
You mean the court record?
The court records are all through the clerk of the district court.
Okay, thank you.
They're the public record holder. Yes, sir. And that's about all I can advise you. I'm not going to help you practice your appeal.
Let's pause on that for a second. 2 attorneys, independently, both refused to represent this man because his strategy would require them to break the very Constitution he keeps claiming to defend. That's like a chef refusing to cook because the recipe you're demanding involves raw chicken and lighter fluid. It's not just unwise, it's dangerous. And yet, Abel still thinks he's found a legal loophole that no one else in history has ever managed to pull off.
Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McLaughlin, that you, being in prison, don't have the financial resources to hire your own lawyer.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in
man
the
must
abundance
speak
of
for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point of
represent.
order. What gives you jurisdiction to appoint a lawyer over me?
I have statutory.
I'm a citizen, sir.
All
Not a
right,
sovereign citizen.
you sound like one.
Well, I'm not.
All right, I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McLaughlin, noting he's made a request to represent himself. Again, that's to be a matter taken up fully before the assigned Judge Satterfield at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or a professional surety bond, though obviously it's not going to affect his current incarcerated status.
Case number 2, and we're already in deeper waters. Meet Jesse McLaughlin, currently serving time in a Kansas prison, now facing a felony battery charge against a law enforcement officer. Instead of focusing on his defense, Jesse's priority is questioning the court's jurisdiction to appoint him an attorney. Sovereign citizens love to start here. It's their bread and butter. But the judge's response makes it clear this is going nowhere fast.
I can place my status on the record if you like.
Yeah, hold on one sec. Yeah, I'll get to you. 1 second. I need to look over some things. Are you representing yourself?
No, sir, I'm not representing myself. I'm presenting myself.
Okay. I mean, do you have a court-appointed attorney going to be speaking with you, or are you going to have a retained attorney?
No, sir.
Calling case Tom King 25 William Boy 00474 in the matter of Roman Curtis Campbell. Mr. Campbell, would you please state your name for the record?
Yeah, I like to state
Just tell
my
me your
name.
name. Yeah, go ahead. Yeah, all I have to do is say it.
I'm Roman Curtis Campbell, a natural person, full life.
Okay, let me ask you this question, Mr. Campbell. Let's try not to talk together. I mean, I'm going to allow you plenty of time to talk because I have to. But are you representing yourself here today? You don't need an attorney, or you want an attorney?
No, sir, I'm not representing myself. I'm presenting myself. I don't need another man to present.
So are you presenting yourself? So you don't want an attorney, you're presenting yourself here today. Is that correct?
Yes, sir.
Okay. All right. Thank you, sir, for that.
The classic SovCit defense. I'm not a sovereign citizen, but here's a list of sovereign citizen talking points. It's like saying you're not a conspiracy theorist while wearing a tinfoil hat. Judges spot this immediately, which is why this one cuts Jesse off before he can spiral too far. For the audience, this is a great example of how courts keep control when someone tries to turn a legal proceeding into a personal soapbox.
Refusal for collecting fingerprints and data, which the court is ordering that you do that. As I've indicated, I'm in a plea of not guilty on your behalf for this matter. I'll indicate that you're self-representing at this time as well. I do have some other conditions for you before I set bond. You're not to have any direct or indirect contact with Marissa, Maurissa Smith. You're not to return to the premises known as Celeste Road.
That's my home.
Yeah. I'm gonna keep going, and then I'm gonna take all your questions at the end. So no problem. It's not. Just hold on to that question. That's all. You're gonna have plenty of time to talk at the end. So do not return to the premises known as Road, West Bloomfield. You will not assault, beat, verbally harass, intimidate, or threaten any potential witnesses. Personally appear for all court proceedings. Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. You need to provide the court with a valid address within 24 hours of your release. Do not leave the state of Michigan without permission of the court. You will not possess any firearms or other dangerous weapons. You shall refrain from using alcohol, any form of THC, illegal drugs, or using any medication. You must contact pretrial services within 24 hours of your release. That's at the 48th District Court in Bloomfield Hills. Pick up no new.
And here we go, our self-proclaimed Prince of Morocco. According to him, his royal lineage and a treaty from 1836 give him immunity from domestic violence charges in Michigan. The reality? That treaty doesn't apply to individuals in criminal cases, and no amount of heritage claims will override state law. Still, the theatrics are fascinating. He even lists his titles like he's at a medieval banquet. Viewers, how many of you think he actually believes this, versus just using it to dodge accountability?
Like everybody else that's involved with this matter, to place their status on the record, and so that it can be noted. And also, I'm not representing myself. I'm presenting myself. Not only that, I'm not standing a surety to Roman Curtis Kemp Hill in all capital letters, ins legis, corporate entity. So that be noted for the record, please, sir. I
Okay,
also reside in domicile at. That's my address, that's my home. The defendant, witness, or whoever that is, Marissa, she doesn't live there. And so that's where I was kidnapped from. That's my home, sir.
Okay, and I will allow you to go back there one time and one time only with a police escort to obtain some minor personal property. That's with a police escort only. Otherwise, you cannot go to 48th District Court in Bloomfield Hills. Other than that, best of luck to you, sir. Officer, we're all set here. Thank you very much for your time.
If I could, Your Honor, we would like the refusal of the booking process that he not be released until that is completed.
Absolutely. He must submit, as it relates to the booking, he must submit to the booking processing in this information, including fingerprints, which is the.
For cases for sovereign citizens and 4 lessons in what not to do in court. From cardboard license plates to Moroccan royalty claims, the common thread is simple. None of these arguments hold up in a real courtroom. Judges are patient, but they're not going to indulge legal fantasy land forever. What do you think? Are these people true believers in their own theories, or are they just stalling for time? If you found this breakdown as wild as I did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom moments. Because trust me, we've got plenty more coming.